At the conclusion of this lecture, you will be able to recognize the nature and legal control over insider dealing, recognize the nature and legal control over market abuse, and be able to recognize the nature and legal control over money laundering. The value of shares in a company on the stock market fluctuates in relation to the underlying performance of the company. Amongst other things, good company results will lead to an increase in the value of shares. It is the fact that share prices fluctuate in this way that provides the possibility of individuals making large profits or losses in speculating in shares. It also, however, provides other people with the opportunity to take advantage of their close relationship with particular companies in order to make profits from illegal share dealing. Such illegal trading in shares, known as insider dealing, occurs when someone trades on the basis of price-sensitive information before the general public has access to that information. Insider dealing is a crime under Part 5 of the Criminal Justice Act 1993. Section 52 of the Criminal Justice Act sets out the three distinct offences of insider dealing. An individual is guilty of insider dealing if they have information as an insider and deal in price-affected securities on the basis of that information. An individual who has information as an insider will also be guilty of insider dealing if they encourage another person to deal in price-affected securities in relation to that information. An individual who has information as an insider will also be guilty of insider dealing if they disclose it to anyone other than in the proper performance of their employment, office, or profession. Therefore, it can be stated that under Section 52, that an individual who has information as an insider is guilty of insider dealing if they deal in securities that are price-affected securities in relation to that information. They are also guilty of an offence if they encourage others to deal in securities that are linked with this information, or if they disclose the information other than in proper performance of their employment, office, or profession. The Criminal Justice Act goes on to explain the meaning of some of the defined terms. Section 54 defines what securities are covered by the legislation, and these are set out in the second schedule to the Act, and specifically includes shares and debentures. Dealing is defined in Section 55 as acquiring or disposing of securities, whether as a principal or agent, or agreeing to acquire securities. Section 56 defines inside information as relating to particular securities, being specific or precise, not having been made public, and being likely to have a significant effect on the price of the securities. Section 57 states that a person has information as an insider only if they know it is inside information, and they have it from an inside source. The key here is that the information is not available to everyone and is obtained secure information. The section then goes on to consider what might be described as primary and secondary insiders. The first category of primary insiders covers those who get the inside information directly through either being a director, employee, or shareholder of an issuer of securities, or having access to the information by virtue of their employment, office, or profession. A secondary insider, in turn, refers to any other person who knew or ought to have known that the information in his possession was inside information. On summary conviction, an individual found guilty of insider dealing is liable to a fine not exceeding the statutory maximum and/or a maximum of 6 months' imprisonment. On indictment, the penalty is an unlimited fine and/or a maximum of 7 years' imprisonment. There are a number of defences to a charge of insider dealing. For example, Section 53 makes it clear that no person can be so charged if they did not expect the dealing to result in any profit or the avoidance of any loss. There is the possibility that the person who benefits from the information, which belongs to the company, will be required to account to it for any profit made. This would certainly be the case with regard to directors who engaged in insider dealing, as they would have breached their fiduciary duties. Market abuse can be defined as any behaviour, action or inaction, anywhere in the world, directly or indirectly affecting investments traded on a UK market that is likely to be regarded by regular users of the market as falling below the standard reasonably expected of a person in that position, and which is at least one of three types. Based on information not generally available to the market, but which is likely to be regarded by a regular user as relevant in deciding the terms on which to deal in such investments, i.e., insider dealing. Likely to give a regular user a false or misleading impression as to the market or value of such investments, i.e., misleading statements and practices, or regarded by a regular user as likely to distort the market in such investments, i.e., the rigging of the market. It is also indirect market abuse if a person requires or encourages by action or inaction another to engage in behaviour that, if done by the defendant, would have amounted to direct market abuse. Market abuse can thus be committed via an innocent third party and by one or more persons acting together. The Financial Services and Markets Act came into force in the year 2000. Part 8 gives the Financial Services Authority the power to impose civil penalties for market abuse. Previously, the UK has largely relied on criminal sanctions against any forms of market abuse, namely, the common law crime of conspiracy to defraud to cover rigging of a market. The statutory offences of misleading statements and market manipulation, reenacted in the Financial Services and Markets Act as misleading statements and practices, and separate legislation making insider dealing a criminal offence. All of these criminal sanctions have been retained in the new regime, and the Financial Services Act given the power to prosecute the statutory offences. Money laundering is the process by which the proceeds of crime, either money or property, are converted into assets, which appear to have a legal rather than having an illegal origin. The aim of the process is to disguise the source of the property in order to allow the holder to enjoy it free from suspicion as to its source. The process usually involves three distinct phases. Placement is the initial disposal of the proceeds of criminal activity into apparently legal business activity or property. Layering involves the transfer of money from business to business or place to place in order to conceal its initial source. Integration is the result of the previous procedures through which the money takes on appearance of coming from a legal source. Money laundering was first made a criminal offence in the United Kingdom under the Drug Trafficking Offences Act of 1986 and is now regulated by the Proceeds of Crime Act 2002 and the Money Laundering Regulations of 2007, together with the specifically anti-terrorist legislation such as the Prevention of Terrorism Act 2005. The Proceeds of Crime Act seeks to control money laundering by creating three categories of criminal offences in relation to the activity. Laundering. The first category of principal money laundering offences relates to laundering the proceeds of crime or assisting in that process and is contained in subsection 327 to 329 of the Act. Under section 327, it is an offence to conceal, disguise, convert, transfer, or remove criminal property from England and Wales, Scotland, or Northern Ireland. Concealing or disguising criminal property is widely defined to include concealing or disguising its nature, source, location, disposition, movement, ownership, or any rights connected with it. These offences are punishable on conviction by a maximum of 14 years imprisonment and/or a fine. Failure to report. The second category of offence relates to failing to report a knowledge or suspicion of money laundering and is contained in subsections 330 to 332. Under subsection 330, it is an offence for a person who knows or suspects that another person is engaged in money laundering not to report the fact to the appropriate authority. However, the offence only relates to individuals, such as accountants, who are acting in the course of business in the regulated sector. The offences set out in these sections are punishable on conviction by a maximum of 5 years imprisonment and/or a fine. Tipping off. The third category of offence relates to tipping off and is contained in section 333, which makes it an offence to make a disclosure which is likely to prejudice any investigation under the Act. The offences set out in these sections are punishable on conviction by a maximum of 5 years imprisonment and/or a fine. The money laundering regulations came into force in December of 2007. It implemented the European Union Third Money Laundering Directive. All businesses that are covered by the regulations have to put in place suitable anti-money laundering controls. If the regulations apply to your business, you must put these controls in place as soon as possible. The money laundering regulations apply to a number of different business sectors, including financial and credit businesses, accountants, and estate agents. If the company is covered by the money laundering regulations, there must be certain controls to prevent it from being used for money laundering. These include assessing the risk of your business being used by criminals to launder money, checking the identity of your customers, checking the identity of beneficial owners of corporate bodies and partnerships, monitoring your customers' business activities and reporting anything suspicious to the Serious Organized Crime Agency, making sure you have the necessary management control systems in place, keeping all documents that relate to financial transactions, the identity of your customers, risk assessment, and management procedures and processes. Making sure that your employees are aware of the regulations and have had the necessary training. In conclusion, insider dealing occurs when someone uses sensitive inside information for their own use without a lawful reason to do so. Market abuse relates to any behaviour that will affect the UK financial market that is not reasonable. Money laundering refers to methods used to hide the proceeds of crimes in order to make the source look legitimate.